All right, everyone, please be seated. We are going to start this session. Canberra is a meeting place between Sydney and Melbourne, and this session is also a meeting place of two distinguished young scholars from University of Sydney and Trobe, Melbourne. The topic is about decentralisation, corruption, and a law, but mostly the corruption is not going to be there. It's more about decentralizations and about particularly constitutional court. We have the first speaker, Dirk Tomsa from Trobe University, who is an expert in electoral and party politics. He has written a book about Golkar, but he asked me not to mention about it because he is more into comparative politics. So, Dirk, please.
All right, thanks, Amrih. Thanks, everyone, for staying on. So, everyone who was here last year will, of course, have heard many papers about decentralization, but we've decided to keep it in this year's update as well as one topic because decentralization was obviously one of the key political developments that did happen during the Yudhoyono years. The legislation was, of course, put in place before Yudhoyono actually became president, but his task was then to actually implement it. And as we all know, implementation of laws is often much more difficult than drafting them, although in Indonesia drafting them is also often a lengthy process. But I do not want to rehearse the arguments or the statistics from last year in any great detail, even though I think it's important at the beginning to provide a context briefly. So I will talk just very briefly about what I think are the main achievements and the main shortcomings of Indonesia's decentralization program. But then what I want to focus more on is the attempts by the Yudhoyono administration to reshape decentralization in line with what maybe Yudhoyono, though it's often hard to tell what he actually wants, but maybe more in line with what his ministers wanted regional autonomy or decentralization to look like at the end of the Yudhoyono presidency. So I'll focus on three issues in particular, the Pemekaran process and the Pilkada process, the regional elections and the splitting up of administrative entities. Then the issuance of licenses and permits and the right to collect taxes at the local level. And lastly, about the increasing fragmentation of party politics at the local level, which has been a thorn in the side of many national level politicians as well. And towards the end, I want to illustrate a little bit of trying to what SBA was actually thinking about these various issues. And against, or I'll do all that against the backdrop of very divergent views of decentralization within Indonesia, which I'll sort of give by way of background at the beginning. So just, this is background basically, and a bit of a repeat from last year. So if anyone who was here last year can perhaps recognize these points. So it came up earlier, I think, in Hal's talk already. There have been advances in regional development. There have certainly, there has been no deterioration of economic development due to decentralization. We can, of course, also view it from the other perspective and say there has also not much significant improvement. In particular, the gap between East and West is still pretty much pronounced. Not much has actually happened there due to decentralization. We have seen improvements in service delivery, again, in some areas, not in all areas. So maybe a shortcoming is that this has not been spread very evenly across the country, but that could probably also not have been expected in the first place. Some regions have clearly seized the opportunity that decentralization provided, others have not. But I think it is an achievement that we have actually seen clear initiatives at the local level from some local governments to make use of the opportunities that regional autonomy provided. We have seen improvements in accountability through elections since 2005, since the introduction of the direct local elections. Previously, as most of you will know, between 1999 and 2004, local leaders were indirectly elected through the DPRDs. Once local elections were introduced, we could see the opportunity for voters to directly punish or re-elect candidates that they liked. So that was a plus. On the other hand, you see on the right-hand side, money politics, vote buying, dynasties, elite dominance. These are all the flip side, basically, of this. On the one hand, yes, the mechanisms for vertical accountability have been put in place, but they have been captured to a large extent, unfortunately, by established elites, often powerful families. And yet again, moving back to the achievement side, we have also seen the rise of reformist local politicians, no one more prominent, of course, than the newly elected president, who made his way through the local system from Solo via Jakarta now to the presidency. And we should perhaps also not forget that decentralization in some ways also helped ease separatist sentiment. We have special autonomy, of course, for Papua, West Papua, and Aceh. And I won't go into that in great detail because we have a separate paper about domestic security tomorrow. But these are some of the positive effects. I mentioned already some of the shortcomings. The last bit I want to highlight is that as a result of decentralization, generally we have seen quite a distinct fragmentation of socio-political activism that extends into political parties at local level, but generally now, I think that came up in Stephen's presentation as well, we have seen an explosion in the number of stakeholders at the local level, to the extent sometimes that makes it very difficult to actually run local governments. And I come back to that shortly. Now, so given that there are pros and cons, naturally there are some people who see decentralization in a positive light, others are more critical. Within Indonesia, there are two distinct groups, I think, that are largely in favor of decentralization. The local elites that have benefited from these new processes, that have occupied the new positions available to them. But also, interestingly, and that was mentioned last year already in Marcus' presentation, the general public. Overall decentralization, despite all the negative press about local corruption, about complaints from business communities about local taxes and permits, etc., the general public is overwhelmingly in support of decentralization. I've been doing some work in Sulawesi and Maluku in the last few years, and that included, amongst other things, a survey conducted by LSE for me. And one of the questions in there was about the Pemekaran process. And this was done in North Sulawesi and in Maluku. And you see the numbers here that the overwhelming majority views the Pemekaran process in particular as very positive. Results were not quite as stark, but still very positive if it comes to the views of local corruption versus national corruption, the prestige of local leaders versus national leaders. So clearly, decentralization was viewed very favorably in many of those questions, and in particular, the one on Pemekaran, which, of course, on the other hand, by people like Amawan Fauzi, the Minister for Home Affairs in Yudhoyono's second term, has been viewed very, very negatively. So we have this different views of regional autonomy, and against this background, we need to see the efforts that have been initiated by the government, especially since 2009, started actually already a little bit earlier, but in particular since 2009, to try to redesign or reshape regional autonomy. So as mentioned in the introductory remarks, I want to focus on a few issues. If I had more time, then I could cover more, but I think these were perhaps the most prominent and sometimes contentious issues related to decentralization that occurred over the last 10 years and especially over the last 5 years. One was the moratorium that SBA issued about Pemekaran. One were the efforts to redraft the legislations about regional elections and regional government. One, and that feeds into this, especially the law about regional government, the redistribution of authorities between the districts, the provinces, and the national level. The efforts to curb the excessive use of local taxes by local governments. And finally, efforts to try to curb the quite excessive fragmentation of local party politics at district and provincial level. Okay, so first of all, the Pemekaran issue. As we saw, it's very popular amongst ordinary people, but the central government doesn't like it. They have to pay a lot of money to all the new districts. And here there are actually, SBA is actually on record with some statements that he regarded Pemekaran and the constant creation of new administrative entities as ineffective. He claimed that most of the new regencies were not achieving their goals, even though it was never really clear against what goals they were actually measured. But this explosion of districts to more than, I think we have more than 500 altogether now, municipalities and districts, that was clearly something that the government was trying to rein in. And the trigger came when in 2009, a local politician from Sumatra actually died after the bid for, I think it was Tapanuli district, for that new district to be created. There was a riot, and he suffered, I think, was it a heart attack or something, so he died in the aftermath of this riot, and then Yudhoyono said, okay, enough is enough. He had urged an implementation of this moratorium already earlier, but only after that did the parliament endorse that as well. So following that, Yudhoyono instructed his bureaucrats to assess the successes and failures of the new regional entities, the new districts, and came up in 2011 with the so-called grand design for the restructuring of regions. This entailed various regulations that would make it more difficult for new regions to be created, but the government did concede that the trend could not be stopped altogether. So they pictured that Pemekaran would continue, but they wanted it at a lower pace, and they wanted the central government to have better control over the process. This, however, was resisted in Parliament because, of course, Pemekaran means new laws that need to be passed in Parliament, and that means incentives for the DPR to keep this process ongoing, because there are, of course, various perks that they can benefit from. Local elites also wanted it to be ongoing, and so even though for a while the creation of new districts was stopped by 2012, the DPR had issued a law to create the North Kalimantan province, and others followed. At the moment, I think there are two laws currently with the government to endorse a further, I think, also 87 new entities. Hasn't been signed off by the government yet, as far as I know. So this effort to stop this clearly failed. Whether this moratorium and these new guidelines will be implemented in the future is questionable. They were meant to be inserted into the law on regional government, but that has not been passed either by the parliament. So it's quite unlikely, I think, that the guidelines will become much stricter, and even if they are, that this will actually be implemented. So here then the government, I think, more or less failed in its effort to stop this process. Now, revising the law on local election, that's been giving me a headache in the preparation for this talk, because following the positions of the various stakeholders there over the years has not always been easy. The government has been trying to, or came out with a proposal to abolish local elections from 2010 onwards, 2011 onwards, when they drafted legislation to shift elections at the local level back into the local parliaments. The position changed over time. At one point it was that the government wanted that only indirect elections for the governors, but not for the bupatis and mayors. At another point they shifted that around. Then the latest is, of course, as you will know, that now they're supporting the direct elections again. Have sort of withdrawn that. And the latest that I read was that they have now submitted 2 drafts to Parliament, so that Parliament can basically choose. this lack of consistency was captured quite neatly in a statement by SBA in 2013 when he was asked about those two main options in these discussions, direct elections or indirect elections, what he preferred, and his answer was terserah. So maybe this is better, maybe that is better. So basically this discussion was left to his Minister of Home Affairs, Gamawan Fauzi, who, as I said, had pushed for the abolition of the direct elections for a long time. Now it seems as if Parliament is the driver of abolishing it, and the government is seeking to redefend direct elections. So, as I said, this has been very difficult, actually, to determine. The positions between within the parties in Parliament have frequently shifted. Now, after the 2014 election, we seem to have this dividing line between the Merah Putih coalition and the other parties. But it wasn't that clear-cut for quite a while. Some parties have been consistent, others have not. The government has not. So again, this is now due to be decided next week, but there's no guarantee that it will. There has been a massive public outcry over this, initially in 2011, and right now that the bill is being is due to be passed again, there's a massive campaign again from the public to try to stop that. And we talked about Yudhoyono's sensitivity to public pressure, and arguably that was one of the reasons why he now backed down again and said that he wants direct elections to be maintained. So here, the initiative initially came from the government, but it shifted after a while, so a reform of this is not yet in sight, and it's doubtful that this will be passed within Yudhoyono's term. Okay, the restructuring of the authority to collect taxes and issue permits. This goes back, efforts to sort of revise this go back to the time before Yudhoyono became president, because initially when decentralization began, almost instantaneously local governments started to issue permits and licenses in the forestry sector, in the mining sector, and often issuing multiple licenses for the same sites, trying to cash in on these new authorities. There was also the issue about local taxes that has been argued to make Indonesia less competitive and make do business, or make it more difficult for business at the local level. So the central government has actually revoked over the years more than 1,000 of these local instructions, the so-called perdas. And they tried to make this process more effective in 2009 when they passed the law on regional taxes and usage charges that defined a specific number of items which could be charged at the local level. But as ever, and Sam Button has written about this, already almost immediately after the passing of this law, there were cases where it appeared as if local governments were finding loopholes. They were not reporting all the perdas. The Ministry of Home Affairs doesn't have the capacity to collect all the data. So even though they are actually, in this case, there was a successful initiative between the government and parliament to actually craft a new law, its implementation is also questionable. Now the latest initiative from the government, from the central government to tackle this is to shift the authority over forestry, mining, marine resources, and one other thing, four key sectors about natural resources, to shift the authority of this to the provincial level, back from the district level to the provincial level, to try to perhaps make it a bit easier to monitor this if it moves up one step. And finally, curbing local party system fragmentation. The national party system is, of course, a multi-party system, but at the local level, between 1999 and 2009, we have seen a consistent increase in the number of parties making it into parliament for a number of reasons, but perhaps the most important one is that at the local level, the parliamentary threshold regulation that kept small parties out of the national parliament was never implemented. So we've seen parliaments at the district level in eastern Indonesia and Sumatra in particular, parliaments of 25 members with 17 or 18 parties in there. So that has made it very difficult for local governments, executives to deal with these parliaments. Of course, if there are fewer parties, these parties are not always consistent and coherent either. But effectively, these parliaments are just gatherings of individuals, of clientelistic networks that pretend to act upon in the name of political parties. Now, in this case here, we've seen a convergence of interest between the central government and the parliament in tackling this. The parties wanted this to change, the government wanted this to change, so the 2012 election law contained regulations that made it much harder to register for the 2014 election, which the KPU then implemented quite stringently, and as a result, we saw that only 12 parties actually competed in this year's election, which then naturally reduces the number at the local level. If you had previously 15, 17 parties in there, now only 12 were allowed to run. The law also initially contained a threshold reform, but that was later struck down by the Constitutional Court, and that shows you that even these reforms were contested at the local level because their local parties, the smaller parties, were keen to maintain these avenues to power if they couldn't go through the big parties. Okay, and as I approach the last minute, a few words on SBA. I've already mentioned the statement that is up to you. As in many other fields, and I have a feeling that this will come up in the coming sessions tomorrow as well, SBA took largely a hands-off approach in this debate. There are various statements of him in some of these debates. For example, about the Pilkada in 2010, he said that he supports direct elections. Then his home minister basically pushed for the abolition of that, and he did not intervene. Then came the statement, maybe both options have their merits, I don't know. And now he says, now we want to retain them. So no leadership clearly there. He did appoint a special advisor for regional autonomy, Felix Wangai, but he was rarely ever seen either to perhaps sort of express the opinions of the presidency. The government's overall proposals were often hampered by conflicts of interest between different ministries. So when it comes to collection of taxes and permits, for example, between Ministry of Forestry, Finance, Home Ministry, etc. And of course, SBA was often driven, as we heard before, by public opinion polls. So now that there is this backlash against the indirect elections again, now he's in favor of direct elections again. So overall, we can say decentralization has been a mixed bag. Neither a complete failure, but also not particularly successful. And it's a combination, I believe, of the four main issues that are put here at the bottom that account for this lack of direction. We have seen some reforms, but some look like a recentralization, some look like a shifting of authority from the district to the provincial level, some seem to be targeted only at specific outcomes of decentralization, such as the local party system fragmentation. So SBA did not intervene in any of these debates decisively. He often succumbed to public pressure and then backed a certain opinion. Within his administration, there was no unity. Different ministries pursued different views. And we've seen, as Stephen mentioned, that now there's a huge number of political stakeholders that actually lobby and pressure, and Yudhoyono has not been able to sort of rule over them like a strong president. Thanks.
The next speaker, Simon Butt, teaches at the University of Sydney Law School, has written two books, one on corruption, the other one on Indonesian Constitution. And one coming next year is on Constitutional Court, the topic of his presentation today. Simon?
Good afternoon, everyone. When the conference organisers asked me to speak about both the rule of law and corruption, I enthusiastically agreed without really thinking through how significant, how big those topics are. In fact, probably worth at least a conference each. So I've suffered a bit of a crisis of material when I've been writing my presentation. So I'm going to focus on the Constitutional Court, but I'm going to talk a bit about the KPK along the way, because as we'll see, their plights have intersected a number of times in the past 10 years or so. When SBY came to power in October 2004. It was a pivotal time for rule of law and anti-corruption reform. The Constitutional Court and the KPK, which have been at the forefront of those reforms, hadn't been around for too long. The Constitutional Court only about a year, and the KPK even less. And both were finding their feet, their place in Indonesia's political and legal systems. 10 years on, how have they fared? Well, I think like most of the speakers in this conference, I'm concluding that there have been ups and downs. There have been pretty big downs, actually. Specifically, both the KPK and the anti-corruption, the KPK and the Constitutional Court, have former chiefs in jail serving long sentences for very serious crimes. And both of them have found themselves operating in quite hostile political environments. The Constitutional Court has faced several attempts by the National Parliament to rein in its decision-making. And the KPK has two, at least, commissioners who have been framed for crimes they didn't commit, Bibit and Chandra, as you'll all probably recognise. And perhaps a third, Antasari Azhar, who was the the chief of the Anti-Corruption Commission until he was investigated, prosecuted and convicted for ordering a murder, and is currently serving an 18-year sentence for that. With the bad things out of the way, I think on the whole, perhaps beyond the expectation of most, the KPK and the Constitutional Court have, I think, fared reasonably well during SBY's tenure. I think they've performed the functions they were designed for, at least. And I don't think that was by any means a certainty at the time that SBY took office. I think it's also fair to say, though, that their successes have not occurred necessarily because of support from SBY. In particular, SBY's support for the KPK has been ambivalent at best, and there are plenty of examples where he's taken far too long to act to protect the KPY when it's been under attack, particularly by very powerful people it's been investigating. Now, in my title, I've called the KPK and the Constitutional Court super bodies. I just thought I might explain this. Is it a bird? Is it a plane? No, it's Super Mahfud, the second Chief Justice of the Constitutional Court. Look, I'm not calling them super bodies because I think they're bulletproof, although I think they have dodged a few bullets in the last 10 years. And of course, it's not because former Chief Justice Mahfud can fly, but perhaps he might have some self-inflation issues. And, you know, who could blame him if he's trying to get around Jakarta traffic on the way to work? No, they're called super bodies, usually in a very negative sense, by those who think they've become too powerful on the one hand and unaccountable on the other. Most of these complaints, though, were made by people who were being investigated or prosecuted by the KPK, or parliamentarians who have just had their laws invalidated by the Constitutional Court. But I think in some ways they might have a point. As I'll explain in a minute, I think the Constitutional Court may well have been breaching the separation of powers, particularly by making laws, even though the Constitution doesn't let it, and even though the DPR has passed statutes specifically directed at prohibiting it from doing so. According to some, to make matters worse, the court has continually, staunchly rejected any efforts by the government to allow any outside bodies to monitor the performance of its judges. As for the KPK, well, it's often called a super body too, because it has lots of powers that ordinary police and prosecutors don't, like to tap phones without a warrant. But perhaps its most notable superpower is its remarkable 100% prosecution rate. which, and Marcus will correct me if I'm wrong, I think it's maintained to this day. There have been acquittals in corruption cases, but I don't think any of them have been brought by the KPK. In other words, every time the KPK has mentioned someone as a suspect, has formally charged them with corruption, they've been convicted. And I think a real strength of the KPK has been that it's maintained this prosecution rate even in the face of quite strong resistance when it started pursuing more politically powerful figures. And it's had some real successes in getting convictions. Parliamentarians, even from SBY's party, and very senior police. But, and I'll just finish on the KPK now, I think it's, although it's a fairly impressive conviction rate, prosecution success rate, and it's captured some big fish, it's very easy to overestimate the impact of the KPK. From 2004 to 2012, the KPK prosecuted in around 230 cases, but ordinary police and prosecutors who the KPK was established to circumvent, because they're widely considered to be corrupt themselves, handled 10,000 cases. So the KPK only hears a very small proportion of cases, high profile as they are, can only really be said to scratch the surface. All right, Constitutional Court, a particularly important body, talking about the dispersal of power. It's a new locus of political and legal power, and it has been arguably reserving quite a lot of power for itself over the past few years. It performs constitutional review, which essentially means that it receives cases from people who come to it and who argue that there's a statute that breaches the Constitution, that violates a constitutional right, for example, and if the court agrees, it can invalidate that statute or a part of the statute. This is particularly significant because Indonesia now has a Bill of Rights. I like to tell my students a more legally lengthy protection of legal rights compared to Australia. And also it provides that that elections must be democratic. So the Constitutional Court has tinkered quite a lot with the electoral systems that Indonesia has employed. Another category of cases that has kept the court very busy indeed, electoral disputes. About 1,800 legislative disputes arising out of the three elections that have been held since the court was established, plus 700 Pemilu Kada, regional head electoral disputes. And I'll come back and talk about these in a minute, primarily because the Constitutional Court has just said in a recent case that it no longer has power to resolve these electoral disputes, the Pemilu Kada electoral disputes in particular. The court's issued some very important, I would say, at least has attracted a lot of publicity for deciding cases, particularly important issues. A lot of electoral related cases. I'll just jump straight to the second one. The presidential and legislative elections should, if the Constitutional Court's decision is followed, be held together in 2019 rather than 3 months apart as they currently are. That's just an example of the tinkering with the electoral system. There are many others which I don't have time to go into. Another one which I've found particularly interesting, when exercising control over natural resources, the state cannot ignore adat rights. Dirk was talking about the issuing of licences to exploit natural resources. The Constitutional Court, in this case, another recent case, has put a bit of a roadblock in front of the government just giving rights over particular areas that might be occupied by traditional communities. There, of course, have been many controversial decisions as well, particularly relevant to Australia. The death penalty case brought by several applicants, including some of the Bali Nine, not the Bali bombers, the Bali Nine, and the court upheld the death penalty. 2 of them still remain on death row, even though the Constitution says that there's a right to life, and that can't be diminished under any circumstances. Somehow the court managed to get around that. You'd think it would have needed particularly clever legal reasoning to do that, but wasn't very sophisticated, unfortunately. This doesn't sit well. I've got Bibit and Chandra. I don't know if you can think back to 2009 when Bibit and Chandra, two KPK commissioners, had been arrested on abuse of power charges, and they lodged an application with the Constitutional Court. And for completely irrelevant reasons to the case that they put before the court, the Constitutional Court allowed evidence to show that they'd been framed to be played in open court. It had nothing to do with the case that the court was hearing, but it allowed Bibit and Chandra's the plot to bring them down to come to light, and so the court really played a big part in that. Blasphemy law case, I won't talk about this for too much, but essentially the court allowed the state to regulate the outward expression of religious belief in the names of the religious values of the majority. So just another controversial case, which we can talk about in the questions if you'd like. I just thought I'd go back a step and have a look at the progression of the court via its various Chief Justices, because I think there's a really perceptible shift in the court from Chief Justice to Chief Justice, particularly between the first two. The first being Jimli Asadiki, 2003 to 2008. And he likes to describe his court as mulai dari nol, yeah? Or as my friend Fritz, who used to work on the court, says, from zero to hero. Mulai dari nol started from scratch. I mean, the court started off, as Jimli describes it in one of his autobiographies, as having a constitution in one hand, the court's governing law in another, and not very much money in its pockets. Basically had no office. And I've got a picture here of the hape, the mobile phone that Jimli used as, well, he describes as the first formal address, office address of the Constitutional Court, because it had no office. So now it's proudly displayed in a very grand court building, in the lobby of the court building, although apparently I hear that it's a replica because the original was stolen, unfortunately. So perhaps it wasn't me, but I do view the court fondly, but I'm not perhaps that fanatical. Over time, though, the court built it itself up. Not couch hopping, but building hopping, having its cases heard in the MPR complex, and then I think even in police headquarters for a while, whilst running its operations from a hotel. Eventually it gets its own building, and within a couple of years it's now housed in this grand, court complex. That building behind it is 20 or 30 stories of administration offices. What the court managed to do under Jimli was to establish itself as an independent and clean institution, I think. Perhaps I'm oversimplifying it, perhaps I'm being a bit over-idealistic, but we had finally in Indonesia, unlike the Supreme Court and other judicial bodies in Indonesia, a court that was professional, that had decisions that were easy to criticise but seemed well-intentioned, and was active. Unlike other courts in Indonesia, particularly during the Suharto period, which had judicial review powers, albeit more limited, the Constitutional Court, from the get-go, invalidated legislation from the first case. And under Jimli, it invalidated statutes in 43 cases out of 157 brought before it. I won't talk about the last point because I don't have time. And I think perhaps the most incredible thing is that after the first couple of decisions at least, the government seems to have been reasonably happy to comply with the court's decisions. And this was by no means certain at the time the court began operating. The contesting parties in electoral disputes in particular might come away from the court grumbling a bit, but essentially have accepted the court's decisions. Now under Mahfud, we have, I think, clearly increasing activism. And we have Mahfud hearing more cases during his term as Chief Justice, but also invalidating in 105 cases over 4 years. He issued shorter decisions, and I've had some assistance helping to go through all of the decisions issued by Mahfoud, all of the decisions issued under Jimli, and Mahfoud's are shorter. I think that this indicates, and I get the impression from reading these cases that there's less legal reasoning in them. Jimli, a well-respected academic, wrote papers, published them as court judgments. That's probably exaggerating a little bit. Mahfoud, not such an academic, although he is a professor too, but seems to be more concentrated on solving political problems rather than developing jurisprudence of the Constitutional Court. Now, at the risk of mass narcolepsy, I'm going to just have to bear with me for a minute. I'm about to get a little bit legal. And I think it's really important, to explain how the court has developed as, what I say, a lawmaker. How's it done it? Well, I think it's done it by declaring laws conditionally constitutional. And this first started under Jimli. And the court says, well, the law that you've brought before us, applicant, citizen, it looks a bit dodgy constitutionally. But rather than invalidating it, we're going to let it stay on the books, provided that the government interprets the statute in a particular way. Now, you may laugh, but this is a practice adopted by many European constitutional courts. It's widely considered to be deferential to Parliament, out of respect. I mean, we're not an elected institution, we're only 9 judges. We don't want to interfere with the parliamentary process too much unless we really, really have to. So we're saying we've got a little bit of a problem with this, but as long as you interpret it in the spirit of the Constitution, you'll be okay. And I did this, I've got an example here, in the film censorship case. It's not a particularly important case, but I think it illustrates this clearly. The court is asked to review the constitutionality of censorship of films. It says, well, we need censorship, but the censorship board hasn't been applying the laws very well. So what it needs to do is to go back and apply the censorship laws in the spirit of upholding democracy and human rights. So a very vague condition on the constitutionality. Now, Mahfoud, on the other hand, has really turned it around. He started declaring laws to be conditionally unconstitutional. So the default position was this law is unconstitutional unless the government interprets the law in a way that the court has specified. And if Jimli issued 15 of these types of cases, well, Mahfoud has issued 54 of them. And in these cases, he's been far more prescriptive. There's a great case, which I've called the wedlock case. It was about the marriage law and Article 43 of it, which essentially only gave rights to children born outside of valid marriages to have a legal relationship with their mother. So only the mother was legally responsible for a child born out of wedlock. Now, for various reasons I won't go into, the Constitutional Court found this to be conditionally unconstitutional unless given the meaning to also provide legal obligations to the father. Now, this is adding a legal norm. There's no two ways about it. This is something I think that a legislature should do. I've just picked this example because I think it quite clearly shows how the court is doing this, but it's done it in 50 odd cases. It's making law. It's turning into a quasi-parliament. Now, some, including the court itself, might justify this on the basis that if it were to invalidate laws and wait for Parliament to respond, this would take a long time. And so that lots of legal vacuums would be created. And this is why it takes this approach. It's not undoubtedly true, but the question is, should a court be doing this? Says it all, really, doesn't it? This has been the biggest stumbling block for the Constitutional Court. Its Chief Justice, or then Chief Justice, Akil Mokhtar, being found guilty of taking bribes in Pemilu Kada cases to fix outcomes. of course, being quite famously anti-corruption when he was appointed, and suggesting that perhaps people who were caught convicted of corruption should have a finger removed. He slapped a journalist after the journalist asked whether he should have his finger chopped off. Now, I don't have time to talk about the way the court has decided pemilu kada cases, these disputes about regional elections. But perhaps we could pick that up in the questions if people are interested. I think for the future, much depends on this man here, Hamdan Zuelva, the current Chief Justice. He seems to have started pretty well, handled the 2014 presidential election disputes in particular quite well. And the question will become, can the court carry that momentum into its other types of cases? For example, the review of the MD Tiga law that's currently before it. Thank you.
Just to add a note, Hamdan Zulfa is very popular among the Ibu-Ibu because of his look. And Tempo, I think, is going to make a big poster of Hamdan. All right, question and commentary. Please be succinct in stating your questions or comment. One here, two. Okay, 1, 2, 3. Yeah.
Nadir Hussain from University of Wollongong, to Simon Butt. Simon, you seem to have a problem with KPK 100% success rate. So what seems to be the problem? Because for Indonesians, they want to have a 200% success rate, right? So is it because you're questioning the presumption of innocence, or you're questioning that the KPK could not issue SP3 after they reach penyidikan stage? Or what seems to be the problem? Thank you.
Next one.
Stephen Sherlock from ANU. I'd like to ask Simon the question. He probably knows what I'm going to ask. Your contention is that the MK invalidates unconstitutional legislation. I would suggest that the MK invalidates legislation it doesn't like, or it thinks the public doesn't like. Do you agree with that, and what are the implications?
Okay, last one.
Thank you. My name is Umam from University of Queensland. As we know that KPK has played a significant role in 2014, especially in determining a political configuration in this election. And sometimes we know that it looks like a political instrument, how KPK can be used by the power holders to attack the rivals or to consolidate the supporters, or maybe to, yeah. So in this case, could you, especially for Simon Butt, could you explain to us how KPK's independency and vulnerability to political intervention, especially for political parties and others, and also from bureaucratic pressure, especially for KPK's relation with police headquarters? I think that's really a little bit sensitive issue for them. And besides that, under Yudhoyono's administration, how do you think about the top political leaders, in this case, Yudhoyono as a president, to support KPK to be, to strengthen the KPK as the more independent and, not really vulnerable to political intervention? Thank you very much.
Thank you, Pak Nadir. About to become particularly unpopular amongst Indonesians who want 2,000% success rate of the KPK. I've got a problem with the 100% success rate. I mean, the KPK has better training. They say that they produce more and better evidence when they prosecute their cases. But I just can't accept that in 10 years, over the course of 233 cases, they haven't made a mistake that has would normally result in an acquittal. Just the balance of probabilities don't sit well with me. And I think there's a presumption that once the KPK has mentioned a suspect, has specifically named a suspect, that person is guilty, and it's fueled by the media, I think, and partly fueled because of the KPK's success rate. It's a perpetuating factor, I think. Of course, it's very difficult one way or another to say that there's not witch hunts, but there's something going on behind the scenes that ensures convictions. I haven't read all of the KPK's prosecutions or the decisions resulting from them, but I just find that on the balance of probabilities, the whole purpose of a trial is to try and pick at the prosecution's case, even in Indonesia. And I just can't see how a defence, I mean, these people who get prosecuted for corruption generally hire very, very well-known, good defence counsels. That, you know, if all the processes were followed properly, I just can't see how sometimes they wouldn't win. Once would be good. Sorry, I'm not anti-corruption by any means. I just think that there's a presumption, and it's great. About a year ago, I think in Tempo magazine, there was an article by interviewing a Supreme Court judge by the name of Alcostar, and he said, I mean, it's the title of the interview. You know, if a corruptor's file comes onto my desk, he won't be getting away. Now, what about the merits of the case? What about the merits of the case? I think part of the issue, perhaps that explains the conviction rate, partly is that the definition of corruption under Indonesian law is very, very, very wide. So that even if you don't intend to gain a benefit or for loss to be caused to the state, even if you don't breach a particular law but you breach community standards, you can be done for corruption. Perhaps that's, you know, more of a reason for explaining the success rate of the KPK. But still, it's from a legal perspective, I think there are a lot of lawyers who are a bit uncomfortable about it. And again, they're not necessarily anti-corruption. Is the court a populist one? Essentially, I think that's what your question comes down to, Stephen. I think under Muffwood, yes. Under Gimli, I think there was a bit more academic, legal argument in its decisions, and it made some decisions that perhaps weren't very publicly popular, but it certainly has revelled in its role as this forum for discussion of public law disputes. The Bibit and Chandra case, I think, is a great example of that, which I mentioned before. You know, the court was asked in that case whether there was a presumption of innocence, and that had absolutely nothing to do with whether Bibit and Chandra were in fact guilty of what the police said they were. Yet the court allowed wiretapped conversations to be played in open court, and the plot to frame Bibit and Chandra was exposed. What's the implications of a populist court? Well, unfortunately, I don't think they're very good. I think what happens when a court doesn't stick to the Constitution, when it starts to make things up a bit, and the Constitutional Court, you know, it doesn't do that very often, but sometimes its decisions are so inexplicably inconsistent with previous decisions. You wonder what's going on behind the scenes. But the further the court moves away from the Constitution, the more people ask, well, what's happening? And when something like the Akil Mokhtar scandal breaks, people tend to discredit the whole court, not just that one judge, because there's not this tradition of following, a strong tradition of following the law in the court. So people are less likely to think it's just one bad apple. They're more likely to think, well, the court's on the take and everyone's in on it. Unfortunately, there's the third question, the KPK, about the political instrument. I'm not really qualified to answer that question. I haven't looked at it, but of course, people say that, complain about the KPK being used as a political tool.
Well, okay, one question particularly on decentralization. Quick one? No? Because we run out of time right now. Can we have a couple of more minutes? Okay, it's cut. No, sorry, you can raise the question later. Okay, let's welcome to the next section. Thank you for speaking.